If you're ever accused of a crime today, you cannot be forced to confess. You have the right to stay silent. And the court still has to prove its case without a word from you. That protection did not always exist. Before it did, courts across Europe each built their own way to force a confession out of someone, using instruments, procedures, and even words for the same act that had nothing to do with each other from one town to the next. This is what that looked like. Town by town before anyone tried to standardize it, and where it eventually led one German city to burn 900 of its own people. For most of the medieval period, European courts didn't need a confession at all. They needed God. The accused walked barefoot across 9 paces of red-hot iron, or was bound and lowered into blessed water, and the verdict came from how the wound healed or which way the body floated. It sounds strange now, but at the time it counted as the most reliable method available for finding the truth, backed by a priest who had spent 3 days fasting and blessing the instrument beforehand. In November of 1215, the Fourth Lateran Council banned priests from blessing the water or the iron used in these tests, and without a priest to sanctify them, they stopped working almost overnight. English court records show no ordeals at all after 1219. A method that had lasted for centuries ended within a few years of one ruling from Rome. What replaced it created the problem this video is actually about. The legal system rising up in its place demanded 2 eyewitnesses for a conviction or a confession, and most crimes simply don't have 2 eyewitnesses standing side by side. So the confession became, in the legal writing of the time, the king of evidence, and every town that needed one built its own way to get it. Start in Florence. Renaissance Italian courts operated under a strict rule. Torture was never supposed to draw blood, so Florentine judges leaned on a workaround, applying fire to the soles of the feet, or hoisting the accused by a rope tied behind the back, a method simply called the rope. No blood spilled, and the rule was technically satisfied, even as the shoulders dislocated on the way up. Venice ran its own version a few hundred kilometers away. Inside the Doge's palace, a set of underground chambers known as the wells held prisoners awaiting exactly this kind of questioning, in a room the Venetians called the torment chamber. The preferred method there was known simply as the string, wrists bound and pulled slowly upward until the accused hung suspended, held there until a confession came. The whole process answered to a secret body called the Council of Ten, and their proceedings were never made public, which meant a Venetian could be tortured on a Tuesday and the rest of the city would never officially know why. Spain's Inquisition, further west, ran the most bureaucratic version of all. Interrogators worked from a fixed set of tools and a fixed set of rules. No session was supposed to run longer than 15 minutes. A physician had to certify the prisoner's health beforehand, and modern historians estimate torture was actually used in only about 2% of all Inquisition cases. It looked almost restrained on paper. In practice, restraint depended entirely on what happened inside that quarter hour. One method suspended the accused by the wrists, sometimes weighted at the ankles, then dropped and jerked to a stop. Another forced a cloth into the mouth while water was poured over it from a jar. 6 or 8 jars in the worst recorded sessions, mimicking drowning with every swallow. A third wound cords tightly around the arms and tightened them with the executioner's own body weight, slicing into muscle. In 1622, a prisoner named Benito Ferrer endured 3 full hours of that cord torture without confessing anything, blood running from his arms the entire time. Decades earlier, a man named Manuel de Lucena, one of many Jewish converts to Christianity, still suspected of secretly practicing their old faith, had not been formally tortured at all, only worn down by years of isolation in a Spanish dungeon. And under that pressure, he implicated more than 100 other people by name. A single broken man producing a chain of accusations that outlasted the Bamberg case by a full century. Before we continue, if you've liked it so far, go ahead and subscribe and turn the notification bell on so you never miss the next one. France shows the pattern most sharply because courts a few hundred kilometers apart used completely different methods for the same legal step. In Toulouse, the milder interrogation stretched the limbs using cords wound tighter with a hand crank. If that failed, the harsher stage forced water through a cloth held over the face, the same drowning sensation used in Spain with a separate version for women. In Metz, the milder interrogation simply meant thumb screws. The harsher stage meant iron chains tightened around the legs. Nancy also used thumb screws for its milder stage, but its harsher one was different again. Same country, same crown, same legal requirement on paper. 3. Completely different sets of tools in practice. The Dutch Republic ran its process with its own particular formality. In The Hague, a suspect facing a capital charge could be sent to what was called the sharp examination, held in a dedicated torture chamber inside a prison known as the prisoner's gate. The accused was laid on their back, tied down at the shins and chest. Knotted cords were then wound around the shins and sometimes the head and turned tighter stage by stage with a stick, the same principle as a tourniquet. Each turn dragged the knots deeper into the flesh, cutting the skin and grinding against the bone underneath, cutting off circulation as it went. It was a different kind of injury entirely from the joint stretching of a rack or the shoulder dislocation of a hanging rope, a slow, local crushing instead. A magistrate had to be present throughout, along with a secretary recording every word, since Dutch law, like nearly everywhere else, required an actual confession before a death sentence could be carried out at all. The practice stayed on the books until 1798. England took a different path entirely. Judicial torture was never written into English common law. But a defendant who refused to enter any plea at all fell outside that protection, and English courts answered that gap with an invention of their own, pressing the accused under stone weights added in stages until a plea came or the body gave out first. In 1586, Margaret Clitheroe, a butcher's wife in York, refused to plead to a charge of harboring Catholic priests, partly to keep her own children from being forced to testify against her. She died under roughly 780 pounds of weight in about 15 minutes, along with the unborn child she was carrying. No confession was ever taken from her because refusing to plead was the entire point. Scotland ran its own toolkit under its own names entirely. One device tore out fingernails. The boots crushed the legs between wedges driven tighter with a hammer at every unanswered question. Even the thumb screws had a local name there. In 1590, a midwife named Agnes Sampson became one of the first targets of Scotland's largest witch panic, one driven personally by King James, who believed storms at sea had been conjured against his own royal ship. Around the same time, a schoolteacher named John Fian was subjected to the fingernail torture until his nails were gone, then had needles driven into the exposed flesh underneath. He confessed. Both were executed. The German territories ran a toolkit of their own, and it followed a set order rather than a single device. Interrogators started with thumb screws, crushing the fingers at the joint. If that produced nothing, leg screws came next, doing the same to the shins. If the accused still held out, the final stage was suspension, wrists bound behind the back, hoisted by a rope thrown over a beam, then dropped short of the ground again and again, until the shoulders and elbows gave way. Before this pattern spread, executions for witchcraft across the entire Holy Roman Empire had totaled around 88 people between 1400 and 1560. In the century after, in the southwest region alone, that number climbed past 3,000. The tools had barely changed. The number of people they were used on had not stopped growing. 8 towns, 8 different named devices, sometimes 8 different words for the identical act of stopping the body from bleeding while breaking it anyway. A person accused in Florence, Venice, Seville, Toulouse, The Hague, York, and Edinburgh within the same few decades could face 7 completely different physical ordeals, justified by the same legal principle. A confession was required, and none had been given yet. No manual tied any of it together, and no minimum standard applied across borders. Each court had built its own answer to the same problem, largely cut off from what its neighbors were doing, and called that answer law. Fixing that gap fell to a young Holy Roman Emperor in the early 1530s. In 1532, Charles V ratified a single criminal code meant to apply across the entire empire, known as the Carolina Code, named after Charles himself. It leaned on an earlier code, written 25 years before for Bamberg itself, by a local official named Johann Freiherr von Schwarzenberg. For the first time, torture required half proof before it could even be authorized. That meant 2 credible witnesses, or 1 witness paired with a partial confession. Leading questions were banned outright, since a question that suggests its own answer produces an answer nobody should trust. Torture was also barred against the very young, the very old, and the infirm. On paper, restraint had finally been written into the law itself. One document, meant to reach every one of those towns at once. What the code didn't touch was what it chose to criminalize in the first place. The same code named harm caused through witchcraft a capital offense, punishable by burning, and handed courts a new category of accusation to point that regulated procedure at. The clearest proof of what that meant came from the code's own hometown, a full century later. Between 1626 and 1631, Bamberg's courts, still operating under that same half-proof standard, tried and executed close to 900 people for witchcraft, roughly 1 in every 13 residents of a city of barely 12,000. Under torture, prisoners routinely named other people just to make the pain stop, the same way Manuel de Lucena had in Spain a generation earlier, and each name satisfied the exact witness requirement the code demanded before the next arrest. The regulation didn't fail by accident. It worked exactly as written. One confession supplying the legal grounds for the next, and that is what fed the numbers. Bamberg's own mayor, Johannes Junius, was pulled into that chain in June of 1628, named by another prisoner under interrogation. He held out for weeks, through thumb screws and leg screws, before repeated rounds of hoisting and dropping finally broke him. What the official record doesn't show is that he bribed a jailer to smuggle a letter to his daughter, describing exactly how his confession had been built, and naming 6 other people forced through the identical process. "Innocent I came into prison," he wrote. "Innocent I was tortured. Innocent I must die." He was burned on the 6th of August, 1628. The letter outlived him. Real change came slower than the law did. A Jesuit priest, Friedrich Spee, who had personally confessed condemned witches during this same period, published an anonymous book in 1631, arguing he had never once met a guilty witch, only innocent people broken by the process. He didn't dare put his own name on it. It took until 1764, and the Italian jurist Cesare Beccaria's writing against torture, for that argument to reach the people who could actually change the law. Prussia abolished judicial torture in 1740. Austria followed in 1776. The Dutch Republic held on the longest of the 3, only striking its own bench from the law books in 1798. 2 centuries after Bamberg wrote the rulebook, courts finally stopped asking pain to answer a question it was never built to answer honestly. So here's what I'm curious about. Out of Florence's fire on the soles of the feet, Venice's string, Spain's cord torture, the Dutch tourniquet, England's stones, and Scotland's boots, which one surprised you most? I'd genuinely like to know. And if this kind of history, the kind that survives in a smuggled letter instead of an official record, is what you're here for, go ahead and subscribe. There's a lot more of it coming.